this point, it's been over 80 days since Meadows was referred for criminal indictment, and yet we've seen nothing from DOJ. I mean, what the hell is going on there?
So there are multiple potential reasons for it. Okay. One is that Meadows finally saw the light of day, would rather not go to prison, and is quietly cooperating now with the J6 committee and with the Department of Justice. Stranger things have happened. You know, pressure bursts pipes. And the more pressure I had to apply to a potential defendant to try to inspire cooperation, eventually, sometimes that pressure broke that pipe and the person would cooperate, even though they were originally determined not to. He could be cooperating. It could be that DOJ is involved in some of their kind of famous legal navel gazing analysis, trying to figure out if it's okay to indict a former chief of staff. The answer is it couldn't be more clear. Meadows provided the J6 committee with tons of documentation responsive to a subpoena. Then when he was called in with another subpoena for testimony to be asked about it, he said, "I'm not coming." Well, guess what, sport? You don't have a privilege for the information, the documents you turned over. So the January 6th committee had every reason to subpoena him, to ask him about that. And he has no legal defense. That doesn't mean there's not a lot of analysis, and as I call it, legal navel gazing at the DOJ, trying to figure out, is this something we can do? That could be another reason that they're slow walking this, because let's be clear, the law says once Congress has made a referral of a criminal contempt charge, the U.S. Attorney for the District of Columbia or the relevant jurisdiction shall present it to the grand jury for its action. The law dictates it. Now, it doesn't say the grand jury must indict. That depends on the evidence that's presented.
Right.
So, but here's another reason they might be slow walking it. If it were me, I would be investigating Meadows for crimes well beyond just contempt of Congress. He might be involved as part of Donald Trump's the evidence is emerging, conspiracy to defraud the United States. And so it could be they don't want to indict a standalone contempt charge. They're rolling it into a larger criminal investigation and ultimately indictment against Meadows. And here's kind of the fourth, if we're up to four, possibility. There's a fifth. One of the possibilities is they're so darn timid that they're not going to do it. I don't believe that for a minute. I know that the colleague of mine, Matt Graves, is now the U.S. attorney. We worked together at the U.S. Attorney's Office. And mind you, 1 week after he was confirmed by the Senate, Steve Bannon was banged out, criminally indicted for his contempt of Congress. That gives me some comfort that Matt Graves is doing the job. But the other thing is, once you indict somebody, all kinds of discovery obligations kick in and you got to start giving over documents. So maybe that's another reason to hold back. And then finally, and this is actually, I think, a really interesting investigative angle. When you indict somebody, you can no longer use that person in a covert capacity. What do I mean by that? We will run defendants as undercover covert sources, because once we've got them and we know the evidence will support an indictment, we're like, you want to start working it off right now before you're ever arrested? Well, Mark Meadows, how about we wire you up, right? That's the old school term. There's all kinds of electronic ways now to wire people up.
Right.
But listen, here's the other thing, and I know I'm running on, but this is kind of the bigger picture question about why are they taking so long? If it were me, I would have indicted Trump long ago or asked a grand jury to. But the other thing I would do is, because Trump doesn't write, doesn't read, doesn't send emails, doesn't text, doesn't do anything. He operates like a mob boss.
Yeah.
I would probably spend the first part of the investigation investigating covertly. I would be up on T3 wiretaps of every flippin' phone that I knew Trump was communicating to, not necessarily his phone, though if I could get a court to authorize it, I would get it. But because why? Because now you need these statements being made by Trump because he doesn't write stuff down. So I would be working covertly longer than I ordinarily would in this kind of an investigation. And then at some point, you got to start locking people up and subpoenaing people to the grand jury.